Ma'am,
Good morning.
you're charged with driving while intoxicated. You're facing up to 6.
Notice how quickly the judge lays out the maximum penalty. This isn't to scare the defendant, it's a legal requirement. But imagine being told that before your morning coffee, 6 months in jail or $2,000 gone. What would your reaction be?
Months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving in its own lane side to side. The officer observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant to have bloodshot eyes, odor of speech, and odor of an alcoholic beverage on her breath and person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted. This is 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results were at 0.137 and 0.132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. You also look prior to DWI's license, please.
Yes, Your Honor.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Judge, on the testing, what is that? I can pass on that message.
Just random testing. No alcohol, no dope,
Okay.
illegal drugs.
Yeah, I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gonna, don't come in 2 weeks though.
No.
Right. But
Okay.
yes, of course.
License is eligible, no priority.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Fleischer for your bond conditions, then you're free to go, man.
All right, thank you very much.
Have a good day.
Don't put your stuff on the stage.
Yeah.
Right here in front of the judge.
Good morning, Mr. Robinson.
Good morning, sir. I'm sorry.
So you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, in Harris County, Texas, at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk.
What did you catch that? Threatening to shoot a security guard instantly escalates this from trespassing to a terroristic threat. That's a huge leap in legal consequences. Do you think the guard overreacted, or was this threat serious enough to justify the charge?
The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is it?
I don't know. When the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, we leave back at 11, and that's when the responded.
What did he say again?
Complainant had repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was therefore trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his plant field first.
He said, I'm going to get my gun and shoot you?
I don't have it both ways. Say the defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Ask a question.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard was the one who was threatening.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do, right?
If I might say real quick, I know you're busy. They have a city ordinance, that's why you can't lay 11. But I was recently jumped, I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what,
I understand. Your Honor.
okay?
Yes, sir.
Because the defendant works this location, and we're not in contact with this location.
What is this? What is this?
It's in the hospital building downtown.
That's the tunnel, that's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer, then more bad blood comes up. They file more charges. That's why.
I understand, I never said that, I ain't tripping. Already filed a motion for discovery inspection, I didn't even have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign a receipt, Victoria. We'll have you take a seat. Let me find your lawyer. and
Yes,
then-
sir.
Okay, please.
Right this way. Judge,
So if you can file this, please, the condition. No going back. Sorry?
Whenever you're ready to stop.
Yeah. I thought I signed it. Yeah, I signed it already.
You didn't know just now.
Yeah, so we can get them out. Mr. Lechuga, come up. We'll have you sign your condition. We'll get you out.
So then the jury box, there's no.
You, Jessica Ariza? Ariza, come on up. Ariza, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 9th, 2025, in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence.
Here's the dramatic pivot. Probable cause is the judge saying, yes, we have enough to keep this case alive. For viewers, this is the point of no return. No matter what she claims next, the trial is officially in motion. Would you feel pressure at this moment if you were in her shoes?
The officer then made contact with the complainant at the residence, who stated the defendant had been intoxicated at a family gathering earlier, and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued?
It needs to be, signed.
Okay, ma'am, I'm issuing now what's called a magistrate's order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine. Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, ma'am?
No.
Do you work?
Yes.
Okay, you work full-time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk. Do not leave until you sign our bond conditions though. Don't worry, because since you'll be monitored for no alcohol, we'll have Fleischer do it. Okay, please. Deputy Miranda will give you an application. All right, good morning, Mr. Lechuga. Good morning. So you're charged with displaying a fictional license, is it plate, right?
That's it.
You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant, and the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. You got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because they're not on purpose, or accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
His driver's license is eligible.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Casanova and Mish. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you.
Judge, no driving affidavit?
You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver, advised he did not have any form of ID on his person, and provided his name as Daniel Escamilla, date of birth, April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yeah, he's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Police, if you can send him, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me.